Hello and welcome to Kevin's Corner. I'm your host, Kevin Horner from Gallagher Manning. Thank you for joining me today, this late morning, early afternoon. I thought what I'd talk about today is something that people talk about usually at the end of the year, and I think I alluded to it in a couple things, but I wanted to talk about charitable giving in the estate plan. As you probably know at this point, especially if you care enough to watch the videos, you will realize that the way taxes have gone in the last couple of years, there's maybe less incentive, less chances for deductions, and therefore there's charitable giving has kind of gone down across the board simply because the incentive is less prevalent for people. Not as many people can use it. However, what we have found with a lot of clients is that that's what they want to do with their estate plan. They're just charitably inclined. They give to several favorite charities during their lifetimes. They want to include them when they pass away. And so I thought what I would talk about today was just a couple of thoughts for people who are like that, who are thinking, I'm not doing this because I want to buy a deduction. I'm not doing it for estate tax planning. It's just simply, I believe in this charity or this type of cause and I want to support it in my estate plan, okay? So I figured I could break it down to 4 specific thoughts about this. At this point, you realize I'm good with the numbered lists. First is think about in your giving from taxable sources. And by that, of course, I don't mean estate taxable because that's something different. But think about this. You might have an IRA, a lot of value that's been added into it. And when that gets paid out, if it's a traditional IRA, a 401k, etc., there's going to be an income tax consequence to the beneficiary. Similarly, you might have life insurance that you want to give to someone else. And sometimes people think life insurance is a really easy way of saying, I want to leave a certain amount to my beneficiaries. Now, the difference between the two, especially if you're not going to leave just everything to a charity or you want to leave some to individuals, is consider naming the beneficiary of your IRA the charity. And the reason why is because if you have your estate plan set up this way, that money will go to the charity. The taxes that come out of that money will go to the charity and they won't pay it. They'll get more. Similarly, if you had left that money to an individual, they'd pay taxes. They don't get the full value of it. The life insurance is not taxed, not income taxed. So that is a much better vehicle to leave to individuals or into your estate planning just to get a cash infusion to your beneficiaries. That one's really, really simple. You also probably could see this in churches. A lot of charities are doing this, but IRAs, there's also options to make contributions every year directly from it to the charity, from the IRA, during your lifetime, from your RMDs to the charity to get an extra deduction there. That tends to be a good way of doing it if you're trying to get a deduction during lifetime, but more importantly for what I wanted to say was just consider leaving a taxable source like a retirement fund to a charity just so that ultimately they're not going to pay the tax. You can give a better source of funding to another individual. So that's one, is think about paying out of taxable sources. Number 2 is a little more complicated, which is consider a charitable remainder trust. Now, there's a lot of variety under this as to what this could mean and how it could be, but this is a trust, and in so many words, it's going to leave something to a charity. It could be an income stream to a charity, or actually it could be an income stream to another individual, depending on how you do this, where whatever's left over when you pass away or whatever the event's going to be, that then leaves to a charity. So the reason why people do this is, one, let's say you have something that's highly appreciated, something that you want to get a step up in basis for, or you at least want to get tax washed, you want to leave it to a charity. And depending on how you do this, you might want to leave it to a charity through that kind of a trust. And then you can either take back an income stream or leave an income stream to somebody else. We see that, I think we'll see that increasingly commonly with the IRA laws that changed with the Secure Act, basically see last week, that that because we have no more stretch treatment for most beneficiaries, so that you want that income stream to go to an individual, but not in the way that the Secure Act is setting it up. I think what some people are going to do is they're going to leave their IRAs to a charitable remainder trust so that the money can ultimately end up going to the charity, but the income can come back out over time to the individual. So that gets a little bit more complex, but generally it's a way of both giving the income stream either to yourself, to another beneficiary, and then leftover money to the charity, or to the charity first and leftovers to someone else. Either way can work. You can get deductions based on how much you put in and how much you're paying back out in the income stream. So there's a lot of variety there, but it's a really good tool for certain people. Number 3, something sort of on my to-do list for this year, my resolutions is to get better at working with these, is a donor-advised fund. A lot of financial advisors are familiar with these, but essentially it's a fund you set up that can benefit charities you might set up during your lifetime. And we're finding that it's kind of like what people would want for a charitable foundation, with less restrictions and less complications, so essentially it. So it would be a fund where you can change who your beneficiaries are going to be, the charitable beneficiaries, and be able to even make it so that you could leave money all to it at your estate, at your death. Now, the only real downfall to this is you still have to have a certain minimum amount to set it all up and the fees to get it going, and there's fees, of course, from the management company to administer it. But for some people, especially who have a variety of charities they want to leave things to, or maybe want to be able to change without changing the entire estate plan who those charities are in the future, one option is leaving everything to a donor-advised fund. I heard recently at a conference that I went to that there's even one idea where people, like I said, don't really need the deductions. They can't use them because the standard deduction is so high now, but they still might want to use a donor-advised fund. Say you want to leave money to your church and you're going to leave $15,000 over the course of the year. One idea, because that might not be enough for your deduction, is to set up a donor-advised fund and then add all the money in 1 year to that fund. That'll be enough to get the deduction in the year that you make it, and then the donor-advised fund will pay out to the church or the charity or whatever over the next 5 years. And I don't know if that's going to apply to too many people, but for people who know they're going to make the charitable giving anyway, the people who are already charitably inclined, that's a good way of getting that deduction and basically just being a good steward and stretching everything out. So, and the last one is kind of a minor point, but if this is something that's important to you, it's worth considering, is think about your power of attorney, your incapacity. If you routinely give to charities, you want to make sure that your power of attorney gives your agent the ability to continue that. And you want to be fairly specific in some cases if that's the way it's going to be for you. So this might be if you give, I'll just say your church again. You give your church $10,000 every year spread out over time, and you want that to continue even when you're incapacitated. You want your agent to have the authority to make that kind of a gift. You want to be able to have that track record. They know this is how I do it, and the agent has the authority to continue that. That may or may not be important to you. Some people would prefer not to give any charitable giving once they're incapacitated, the theory being that they need it themselves. There's really no right or wrong, but if it's something that is important to you, you want to make sure it's there. So just to briefly reiterate that, it's 1, try to give to charities out of taxable sources like IRAs if you're not going to just give everything. Number 2, you can consider charitable trusts. That's a good way of getting income back to individuals, or just lump sums, but still being able to fund a charity. It's also a good way of dealing with retirement in the Secure Act age that we live in. 3, consider a donor-advised fund, so that you can fund either, lifetime to set up, and then upon your estate, leave to a number of charities that you've directed in it. And then 4, think about your incapacity planning and continuing to make charitable donations through it. So if you are charitably inclined and you definitely want to make sure your estate plan covers these kinds of considerations, by all means give us a call or look at our website, GallagherManley.com, and you can request a consultation there to go through all of this with one of our attorneys. So thank you very much. If you have any questions, feel free to put them in the comments or send in a message, and I look forward to seeing you all again next Thursday for Kevin's Corner.